Okay, good morning, everyone. I'm very happy to welcome you and open the second day of our conference. We have a very exciting morning ahead of us. Our keynote speaker today is Professor Leora Bilsky from our own Tel Aviv University. She will be talking about business history and transitional justice, the case of transnational Holocaust litigation. Professor Bilsky is a full professor at our faculty of law and the director of the Minerva Center for Human Rights at Tel Aviv University. She earned her LLB from Hebrew University and her doctorate and master's from Yale Law School, and was the clerk of Honorable Aaron Berg at the Israeli Supreme Court. She has served as the editor-in-chief of the political theory journal Theory and Criticism, the editor of law journals such as Mishpatim, Yunei Mishpat, Theoretical Inquiries in Law, and she is the author of Transformative Justice, Israeli Identity on Trial from Michigan University Press, and is currently working on a very interesting manuscript, The Holocaust Corporations and the Law, which will be forthcoming soon, and I'm thinking that probably the lecture is part of that project. So please join me in welcoming Professor Bilsky. Thank you.
Thank you, Doreen, for your introduction, and I want to welcome all of you to Tel Aviv University. We are all here very excited to have you, and I hope that this conference is a good one. So let me begin with the title, with Transitional Justice, and then I'll go to the corporation and to the litigation that I'm interested in. Transitional justice is a field of practice and scholarship devoted to legal responses to mass violence in times of political transition. Transitional justice theories and practices developed out of the third wave democratic transitions in Latin America, Eastern Europe, and Africa. The new democracies were searching for ways to address legacies of human rights abuses committed under the prior authoritarian regimes, without frustrating the democratic transitions which demanded the support of powerful outgoing officials or the business community. Thus, in the 1990s, states that emerged from the atrocity-ridden conflict and repression, such as Chile and South Africa, rejected the idea of trying the previous regime's oppressors and instead set up truth commissions that were deemed more conducive to reconciliation and nation-building, while still providing some degree of justice by revealing the truth about the violations and acknowledging the victims. Transitional justice, as it developed into a field of practice and scholarship, has centered on addressing gross human rights violations through various legal mechanisms, prominent among them criminal trials and truth commissions. Proponents of transitional justice believe that the road to democracy has to include the return of the rule of law, and in particular, investigations of the truth about past human rights violations, as well as the creation of mechanisms of accountability. This emphasis on the rule of law and prosecutions as conditions for democratization diverges from previous understanding in the 1960s that emphasized economic development as a precondition to democratization. Recent transitions raise profound questions about this framework. As Tunisia and other Middle Eastern countries undergo numerous transformations in the aftermath of what we call the Arab Spring, transitional justice offers itself as a natural candidate to serve as a framework for policymaking and analysis. However, the Arab Spring also poses a particularly striking challenge to this human rights, rule of law-based approach to transitional justice, given the centrality of economic and structural injustice in the demands of the people of the region for change. In grappling with the economics under transitional justice, I would like to point to an interesting development that began in mid-1990s in the field of Holocaust litigation. it was a first systematic attempt after Nuremberg to address the role of economic players, in particular the business corporation, in the crimes of the Third Reich, in particular for slave and forced labor. And this under the framework of civil litigation. This development, I claim, offers an important correction to the toolkit of transitional justice. I would like to suggest that in sharp contrast to most truth commissions, the litigation of the 1990s shifted attention to economic history and created, through civil litigation and settlements, mechanisms for compensation, restitution, and, what is interesting for you, historical research. The 1990s class action litigation against European corporations for their involvement in the crimes of the Third Reich offers a unique case study to explore belated efforts to bring economic businesses to accountability. My presentation here is part of the book, a manuscript that I'm currently writing about the Holocaust, corporation, and the law. So let me begin with two gaps in the framework of transitional justice. When we look at the field of transitional justice today, we notice two lacunae that define the boundaries of the field: the invisibility of economics and the absence of historians from truth commissions. Let me begin with the first. The blindness to economic injustice is connected to the dominance of the human rights framework over the field of transitional justice, a framework that focuses on the physicality of atrocious crimes at the expense of structural conditions. Indeed, the emphasis on physical violence and away from economics are the markers of human rights emergence since the end of the 1970s as an apolitical discourse. The second lacuna, the absence of historians, seems at first sight extraordinary, given the importance of truth commissions in the field. As pointed out by Peggy Arthur, transitional justice developed at the same time as the German Historikerstreit, which transitional justice scholars remarkably fail to mention. The explanation goes back to a major shift in how political scientists understand democratization. While relying on theories of modernization in the 1960s, from the 1980s they began relying on theories of elite bargaining. With legal political reform seen as a sufficient condition for democratization and transitional justice institutions given the mandate to complete their investigation within a short time period, usually 2 years, there was little room for the complex narratives of historians reaching far into the past and deep into economic and social context. Historians, for their part, have stayed away from didactic, official history writing that characterized the field of transitional justice. Although these two gaps, the absence of economics and the absence of historians, have been noticed by others, they have not been analyzed together, and the relationship between them has not received scholarly attention. As a result, they may appear as innocent omissions that could be fixed by simply broadening the mandates of transitional justice institutions to examine economic injustice and the behavior of business entities, and by including historians on the staff of truth commissions. And there are indeed some, the articles that are written on this recently, these are exactly the proposals of how to correct it. And I would like to raise the possibility, however, that these two lacunae are connected and are structural, and hence these proposals, I am not convinced how they would really correct the omission. When we look at these two lacunae jointly, they point to a structural limitation of the field of transitional justice. They are linked to a fundamental assumption prevalent in the field that democratization is a legal political phenomenon that can be disconnected from significant economic redistribution. This assumption, in turn, reflects the apolitical orientation of the field of human rights more broadly. While the apolitical orientation of human rights opened new possibilities for its expansion during the Cold War, as it removed it from the big ideological and economic divides between communism and capitalism, It also crippled it as a tool to address structural economic problems. Thus, we are left with two fundamental questions. One, would the introduction of historians, and in particular economic historians, and a broadened research mandate for transitional justice institutions to include the relationship between economics and politics not constitute too much of a repoliticization of the field and therefore a threat to the field's legitimacy? That's the first question. And the second, conversely, if transitional justice institutions embraced economic history without simultaneously questioning the field's assumptions and structure, would this embrace portend any real change? So these are the questions. Usually, these types of questions remain at the level of theory and speculation. However, the 1990s litigation offers a unique test case for the embrace of economic history as part of a larger attempt to bring businesses to accountability. The Transnational Holocaust Restitution litigation took place during the 1990s in American courts against European business corporations for events that took place in European soil 50 years earlier. The wave of Holocaust restitution began in 1996 in US courts with class actions filed against Swiss banks on behalf of Holocaust survivors, some living in the United States, but most of them abroad, for the restitution of monies held in bank accounts since the war. And soon it expanded to include claims against banks in other countries as well as claims for life insurance plans. In 1998, Swiss banks were the first to settle for an unprecedented $1.25 billion. Shortly thereafter, a series of claims against German corporations for the use of slave and forced labor during the war led to the establishment of a $5 billion fund to which the German government and corporations contributed in equal shares, and to the signing of an executive agreement between the government of Germany and the United States, whereby in exchange for Germany's agreement to compensate victims, the United States undertook to make efforts to have any future litigation against the defendants dismissed. The lawsuits brought by private attorney in civil courts were harshly criticized because they shifted attention away from murder and genocide to the economic aspects of the Nazi crimes. In addition, the litigation ended by settlement, as I said, with no written judgment, seeming to fail in its task to bring about justice or to even bring businesses to take responsibility for their deeds. But alongside the monetary settlement, the lawsuits brought about the establishment of historical commissions, and thus historians wrote the main textual product to come out of the litigation, the commissioned histories of corporations. Indeed, this was one of the most interesting results of the litigation, a new model of historical research, historical commissions consisting of distinguished historians from various countries with the mandate to investigate the accusations and produce a written report. These commissions were created in the course of the litigation, and some continuing their work after settlement had been reached. Do they constitute a new model that can be used? With transnational Holocaust litigation, we have a fascinating test case for the embrace of economic history in the aftermath of violence. Although it happened many decades after the Nazi crimes, it is not a Holocaust-related oddity. And in my view, it reflects broader trends in transitional justice and human rights practice. For example, we witness a similar development with civil litigation brought in US courts against multinational corporations for complicity with the apartheid regime in South Africa. And this long after local transitional justice measures such as Truth and Reconciliation Commission have been completed. The apartheid litigation is itself part of a broader attempt to hold business accountable for participation in mass violence and socio-economic injustice under the Alien Tort Statute in US federal courts. Likewise, the US litigation influenced and inspired European national courts in France, Italy, and Greece to take on tort litigation in connection with the Holocaust, which is very unique because it takes on the public law measure. Most famous is the French litigation against SNCF, the French Railroad Corporation, for participation in the transportation of Jews in horrific conditions to internment camp of Drancy. In my view, the commissioned histories succeeded in providing a complex narrative of economic injustice that foregrounded structural and material explanatory framework for business collaboration with the Third Reich. I base my conclusions on the historical commission of 3 German corporations: the chemical business of the Gusa, the insurance concern of Allianz, and the Deutsche Bank. They were written by Peter Hayes from Cooperation to Complicity, the Gusa in the Third Reich, which discusses the business of chemical company, the Gusa, during the Third Reich, by Gerald Feldman's Allianz and the German insurance business, 1933-1945, which discusses the giant insurance concern's treatment of Jewish employees and customers during the Third Reich, its actions during the war in the occupied lands, as well as the part it played in the Aryanization and Kristallnacht. And Harold James, the Deutsche Bank and the Nazi economic war against the Jews, which focuses on the bank's involvement in the Aryanization of Jewish property. And another book by Jonathan Steinberg, also about the Deutsche Bank, because the commission there divided its projects. These works were chosen among a large number of potential works for being of high scholarly quality and for representing a broad cross-section of businesses. So what can we learn from this commissioned history as a new model for economic truth commissions? The works devote profound attention to an economic player, the corporation, and its role as beneficiary or enabler of violence. A new kind of victim is also the subject of study: forced laborer, victims of Aryanization of property and the workforce, and customers of financial institutions denied access to their financial assets. Thus, instead of physical violence, pain, and death, the reports narrate a story of dispossession and exploitation. These acts could have been, however, discussed in terms of intent, knowledge, or initiative, as is typical for criminal law and had been done in Nuremberg. Yet, the historians delve beyond these questions and examine partial knowledge, reluctant collaboration, and numerous other hybrid concepts that reflect the corporation's position as enabler rather than a direct perpetrator. Moreover, the question of collaboration is examined over time, which allows the historians to move beyond the question of whether or not corporations collaborated to describe how individual officers, corporate culture, and changing conditions in the Third Reich led the corporations to tighten their relationship with the regime. Instead of criminal intent, the books in effect address the banality of evil. Here, the banality of business managers' mindset. While denying the thesis of passivity or victimhood propounded by the corporations from the end of the war, the histories do not go to the other extreme of returning to the Nuremberg thesis of corporations as puppeteers of the Nazi regime. Neither victim nor perpetrator, the reports conclude that the corporations' attempts to conduct business as normal and to maintain their reputation and competitiveness led to increasing cooperation with the regime. I'll jump a little about the details of it, because I don't have time. By emphasizing mundane and commercial motives, the analysis also de-emphasizes ideology and racism as explanatory framework. In fact, taken together, these books offer an alternative explanatory framework of economic colonialism. This material framework helps make fuller sense of the corporation's cooperation with the Nazi state. This is not to imply that the books assign material considerations full explanatory power in the vein of Marxist histories of Nazism written in East Germany during the Cold War. To the contrary, the authors of commissioned histories all appear to espouse the theory propounded by the Marxist British historian Timothy Mason, who, contrary to his colleagues in Eastern Germany, argued for an understanding of the primacy of politics over economics in decision-making within the Third Reich. Yet, they show how in decision-making within the corporation, ideology and submission to pressure exerted by the state interacted in complex ways with commercial motivations. It should also be noted that the books have a broad temporal framework, including the years after 1945. This enables them to address not just corporate behavior during the war, but how the corporations addressed their past during the process of denazification and calls for compensation and restitution. This broadening of the time frame also sheds light on the self-delusion that accompanied the corporations even decades after the end of the war, as the corporations continually claimed that they had been either passive during the regime or victims themselves. The books show how slow and arduous the process of recognizing some measure of wrongdoing has been, and the difficulties of conducting this kind of inquiry. We can learn from this litigation about the conditions that make it possible to introduce economic history into transitional justice. First, we see from the commissioned histories that without full access to corporate archives, it is impossible to conduct this kind of research. Moreover, the decades-long self-delusion of the corporations about their collaboration with the regime suggests that the decision to open archives and investigate the past cannot be left up to the corporations. At the same time, the incentives have to be provided to make access to archives possible. In this litigation, this was provided in the form of settlement and the preclusion of future claims. Corporations opened their archives knowing that whatever was found in them could not be used by victims to sue them in the future, thanks to the settlement. What are the limitations of this new model of historical commission? We should remember that in order for this type of research to be possible, historical research was disconnected from the question of legal responsibility. The legal questions raised in the lawsuit certainly influenced the questions asked by the historians, who focused on slave labor, bank accounts, the production of Zyklon B, etc. Yet, as the historians themselves clarify in their books, the research was conducted neither to establish legal liability nor to determine the amount of damages. As historians, the authors were not interested in legal liability or in making policy recommendations. No legal doctrine impeded the production of complex, contextualized narratives. These books make it clear, however, that there is a price to this complexity, as their findings would be very difficult to translate into legal terms. We see from the case of THL the trade-off between complex economic history and legal normativity. This disconnection between history writing and the law also has political consequences. Settlement enabled the corporations to claim the compensation paid was humanitarian and not legal compensation for wrongs, and to frame the case as a unique Holocaust-related case without precedential value for ongoing struggle to impose legal liability on corporations for human rights violations. I go into it in the book, but I won't have time here. I pointed to the commissioned history as a welcome shift of focus to the corporation. The books also suggest the price, the difficulties of integrating victim perspectives when the main source is the corporate archive. The historians are not only released from the constraints of the law, they are also free of victim-centered focus of transitional justice truth commissions. While the books refer to some rich victims of spoliation, their perspective is absent. And as to forced laborer, they remain faceless in the books. So in conclusion, the commissioned histories of German corporations' wartime behavior constitute a very particular form of history writing. They have striking advantages in comparison with existing transitional justice mechanisms that ignore economic structures. They offer in-depth examination of the social, political, and economic processes that led individual managers and the organization they led to gradually abandon moral principles and serve as important enablers of the Nazi regime. At the same time, the conditions that enabled their writing, in particular legal settlement, have costs that are not negligible. Thank you.